In this subunit, we're going to discuss what type of document qualifies as a writing under the common law statute of frauds. Let's talk about what constitutes a sufficient writing under the common law statute of frauds. So in this subunit, we're going to talk about marriage, year, land executor, and guarantee contracts. We won't talk about the sales contract. We'll have a separate subunit about the UCC approach to the statute of frauds a little bit later. All right, so in this subunit, we're going to talk about several different topics related to what constitutes a sufficient writing under the common law statute of frauds. So we're going to look at the rule by looking at an example of the application of the rule. We're going to talk about specifically what makes a writing, what constitutes a writing, what types of things are writings for the purposes of the statute of frauds, what constitutes a signature for the statute of frauds, what happens if we have multiple writings. Can we have multiple documents? Will that satisfy the statute of frauds? And then we'll talk about substitutes for writings, when full or part performance by one or more parties under the contract will take the contract out of the statute of frauds. Courts will often say full or part performance takes the contract out of the statute of frauds, but conceptually this is a little bit disturbing for me. So I like to think of it as full or part performance as a substitute for a writing. We'll discuss that in a little bit more detail just a little bit later. Okay, so what constitutes a sufficient writing under the statute of frauds? Let's look at an example and we'll apply the common law rule to this example so we'll have a better understanding of how the common law rule works. Mary sends a little note to her assistant, Alice. Alice, I had a conversation with Bob M. today regarding my agreement to sell Blackacre to him for $100,000. Please keep your calendar open for the closing on August 10th, Mary. All right, so is this a sufficient writing under the statute of frauds? What do I mean? Well, if Bob M. sued Mary under this oral contract, would Bob M. be able to use this writing as a sufficient writing under the statute of frauds? Now look at it. Clearly Mary did not intend this writing to be a written contract, but that's not what we're looking for under the statute of frauds. We're just looking for some sort of writing. This is clearly a writing. All right, what else are we looking for? Well, the writing must reasonably identify the subject matter. Does this writing reasonably identify the subject matter of the contract between Mary and Bob? Yes, it does. Blackacre, a plot of land. $100,000, sale, right? My agreement to sell. So this this writing reasonably identifies the subject matter of the contract between Bob M. and Mary. Does the writing sufficiently indicate a contract has been made? Yeah, it does. Look, it says, Alice, I had a conversation with Bob M. today regarding my agreement to sell. So it sufficiently indicates a contract has been made. Agreement to sell. Does it state with reasonable certainty the essential terms of the unperformed promise? Well, what is the unperformed promise? Well, the unperformed promise is Mary's promise to sell Blackacre to Bob, right? So do we have agreement? Yes. Do we have sell? Yes. $100,000? Yes. Seems like we have all the essential terms of the unperformed promises of both parties. Is it signed by the party to be charged? Yes. Look at the end of it. Mary put her name at the end of it. So if Bob M. was to use this document against Mary, it would qualify under the statute of frauds. It is a sufficient writing under the statute of frauds. Now that we have a good idea of what constitutes a writing under the statute of frauds, let's talk about some details. Specifically, let's talk about electronic writings. We live in an age where many of our documents are in electronic form. So a few years ago, the Uniform Electronic Transactions Act was created. It was put out by the Uniform Law Commission, right? One of the parties responsible for putting out the UCC. Under the Uniform Electronic Transactions Act, if the law requires a record to be in writing, then an electronic record qualifies as a writing. So what is a record? What is an electronic record? Well, the Uniform Electronic Transaction Act says an electronic record. A record is anything, and it's a long definition, you can read it on your own, but effectively it's anything that's retrievable in perceivable form, right? Your email, is that electronic? Yes. Is it retrievable in a perceivable form? Yes, I can read my email. So as long as it's retrievable in a perceivable form, it is a record. It is an electronic record. So the Uniform Electronic Transactions Act has been adopted by 47 states and Washington, D.C., the District of Columbia. So it is pretty much the law of the land. The Uniform Electronic Transactions Act applies to a broad category of documentation under the law. It does not merely apply to the statute of frauds. But for our course, we want to understand the consequences of the Uniform Electronic Transactions Act on the statute of frauds. Well, what does it mean? Well, effectively means that these things, emails, text messages, voice recordings, video recordings, these things will all qualify as writings under the statute of frauds. All right, if you remember from our rule, our statute of frauds rule, what constitutes a sufficient writing, the writing must be signed by the party to be charged. The writing must be signed by the defendant, the person who is being sued. So let's talk about what a signature is for the purposes of the statute of frauds, right? A signature is something, a mark, or some sort of sound process or symbol, we'll talk about that a little bit later, that is used to, with the intent to authenticate the contents of the document, right? It's not an intent to sign. When we talk about signature, usually we talk about it as some sort of assent to a contract. My signature is my manifestation of assent to the contract. That's not what we're looking for here. In the statute of frauds, we're looking for something that indicates that the person to be charged is authenticating the contents of the document. This idea is a little bit better explained through some examples. So, for the example, when we looked at Mary's little note to Alice, her assistant, Mary put her name at the end of the note. Why? To authenticate, this note is from me, and I am authenticating the contents of the document, right? Anything, when you put something, your name on something, you're not necessarily assenting to a contract, right? You're putting your name at the bottom of it, you're signing it to authenticate the contents, to say, this is from me, and the contents are from me. I'm authenticating the contents of the document. So when you're looking for a signature, for the purposes of the statute of frauds, you're not thinking the traditional signature as assent. You're thinking of signature as authenticating the contents of the document. All right, how does the Uniform Electronic Transactions Act deal with electronic signatures? Well, it's no surprise the Uniform Electronic Transactions Act says if the law requires a signature, an electronic signature will qualify. Well, what is an electronic signature? It's a long definition, but focus on any electronic sound, symbol, or process. Once again, sound, symbol, or process. Let's look at some specific examples of sounds, symbols, or processes that qualify as a signature. All right, as we said, the Uniform Electronic Transactions Act says that any type of electronic sound, symbol, or process will qualify as a signature as long as the intent to sign is there, as long as the intent to authenticate the contents of the document for the purposes of the statute of fraud is there. So let's look at some common examples. This is the typical way that people electronically sign a document, right? We got the little slashes, the S in the middle, and then just writing the name afterwards. But if you just, at the end of your email, put your name, Mary, for me it would not be Mary, it would be Chris, you're signing the document, I believe, for the purposes of the statute of frauds. My email has a signature block, and so every time I send an email, it has a signature block. Why do I have that signature block? To authenticate that this email comes from me, Chris Gulanello, professor of law. If your voice, on a voice message, you say, this is Mary, I would not say, this is Mary, of course. I would say, this is Chris. So when I leave a message, a voice message, I say, hey, this is Chris. I am authenticating the contents of that voice message, right? This is from me. That's the idea of authenticating the message. Now, the Uniform Electronic Transactions Act, in its comments, said your voice alone on a voice message, on some sort of voice recording, may in and of itself be a signature as long as the intent to sign is present. That's very interesting. You don't even have to say this is Chris or this is Mary or whatever your name is on a voice message to sign it. Your voice alone might be the signature, right? Because we can tell your voice. We can tell if this is your voice or not. And finally, when you're on a website and you click I agree, that is called a click-through. A click-through is a signature. Why is it signature? Well, is it a sound? No. Is it a symbol? No. It is a process. It is a process of signing a document. It's an electronic process. And therefore, under the Uniform Electronics Act, a click-through is a signature. And for the purposes of the statute of frauds, a click-through is also a signature. Now let's talk about what if we have multiple documents, multiple writings under the statute of fraud. Will multiple writings qualify as one writing for the purposes of the statute of frauds? Well, let's just set it up with a hypothetical. Let's say that in our transaction we have 3 separate writings, and on one writing we have the signature of the party to be charged. On another writing we have a material term that we need for the contract. And on a third writing, we have an indication of a contract between the parties. So remember, our rule for the statute of frauds is that we need all 3 of these things: the material terms, we need a signature of the party to be charged, and we need some sort of sufficient indication that there is a contract between the parties. So altogether, these 3 documents would qualify, would be a sufficient writing under the statute of frauds, but we have them in 3 separate writings. Is this allowed? All right, so when we have multiple writings under the statute of frauds, can we admit to the court multiple writings and say the multiple writings together satisfy the statute of frauds? So most courts will say you can admit multiple writings. Multiple writings will qualify as one writing under the statute of frauds if they clearly on their face refer to the same subject matter or transaction, right? So you look at the documents, do they clearly on their face refer to the same subject matter or transaction? Some courts are much more strict. Some courts will say that the documents must expressly refer to each other, not just to the same subject matter or transaction, but they must expressly refer to each other. So, for example, the signed document The signed document must refer to the other two documents in our example. Expressly refer to them. Some jurisdictions are much more lenient. They will say, listen, if you have multiple documents and they don't expressly refer to each other, or on their face they don't necessarily refer to the same subject matter or transaction, come into court, present them to us, get on the stand, and give us your testimony and connect these documents through your testimony. This is the most lenient approach. Once again, I think most courts will take the first approach. As long as the documents refer to the same subject matter or transaction, they will qualify as one writing under the statute of frauds. For the remainder of this subunit, we're going to be talking about what can be viewed as exceptions to the statute of frauds or substitutes for a writing. The issue is, when will full or part performance by one or both of the parties under the contract take it out of the statute of frauds? Once again, assume we have my leg, we have one of those contracts that's within the statute of frauds. Will full or part performance take the contract out of the statute of frauds? As I said earlier, this kind of thinking is disturbing for me. It's just kind of nonsensical. If the contract is within the statute of frauds, it's within the statute of frauds. Full or part performance shouldn't take it out of the statute of frauds. I like to think of it as a substitute for a writing. So when a contract is within the statute of frauds and we have full or part performance by one of the parties, will that full or part performance act as a substitute for a sufficient writing under the statute of frauds? Think of it in whatever way is useful to you. So in the remainder of this subunit, we're going to talk about when full performance will take a contract out of the statute of frauds, or when full performance will be a substitute for a writing. We'll also talk about what type of performance under the 1-year provision will take it out of the statute of frauds, and then what type of performance under the real property, the land provision, will take that contract out of the statute of frauds. All right, let's talk about full performance. When will full or part performance take a contract out of the statute of frauds? A contract that would normally be within the statute of frauds. So here's the thing. Under the common law, my leg, all of those contracts, full performance by both parties will take the contract out of the statute of frauds. In other words, if you have an oral contract that is within the statute of frauds and would normally require a writing, would normally be unenforceable without a writing, if both parties have fully performed under the contract, then the contract is no longer under the statute of frauds. I guess the idea is that if you go into court now and both parties have performed, there is no doubt in the court's mind that there was a contract. All right, let's talk about the 1-year provision. When will full or part performance under a contract not to be performed within a year of the making, when will full or part performance take that contract under the statute of frauds? Or another way of thinking it, when will full or part performance be a substitute for a writing for an oral contract not to be performed within a year? The majority approach is that if either party under this type of contract has fully performed, then the contract is no longer under the statute of frauds. In other words, you don't need a writing for it to be legally enforceable. Once again, majority approach, if either party under the contract has fully performed a contract not to be performed within a year, that contract no longer requires a writing to be enforceable. It is no longer within the statute of frauds, or you can say the full performance by one of the parties acts as a substitute for a writing. So if we enter into a contract for you to work for me for 2 years, and I will pay you $100,000 for those 2 years, if I have fully paid you, the contract is no longer within the statute of frauds. We don't need a writing for it to be enforceable. Or if you have already fully performed, you have worked for 2 years, then the contract is no longer within the statute of frauds. It is enforceable without a writing. The minority approach is that full performance by one party within a year takes the contract out of the statute of frauds. So in the majority approach, just full performance by either one of the parties, no matter when it occurred or how long it took, takes the contract out of the statute of frauds. In the minority approach, full performance by one of the parties within a year, or in a year or less, we should say, takes the contract out of the statute of frauds. A writing is not necessary. All right, continuing our discussion of what type of performance, if we have full or part performance by one or more of the parties, will it take the contract out of the statute of fraud? So let's talk about the contract for the transfer of an interest in real property. The majority approach is that full performance by the seller. Well, what is full performance by the seller? Conveyance of the property to the buyer. So full performance of the contract by the seller takes the contract out of the statute of frauds. In other words, if the seller has already conveyed the land to the buyer, that is enough. The contract does not require writing to be enforceable. Other courts, however, have said that if a buyer has taken possession, made some payment to the seller, and made some improvement to the land, then that contract is no longer within the statute of frauds. So in a contract for the transfer of an interest in real estate, if the buyer has taken possession, made some payment, and made some improvement to the real estate, that contract is no longer within the statute of frauds. It will be enforceable even though there is no writing. All right, finally, let's talk about some secondary arguments if a contract is not enforceable because there is no writing and it is within the statute of frauds. We might argue promissory estoppel. So say, for example, we enter into a contract, it's an oral contract, it's one of those contracts that's within the statute of frauds, and one of us has performed, but we do not have a writing. Under the statute of frauds, this contract would not be enforceable, but I might use part performance, and the restatement has a specific provision for this. This is promissory estoppel in the case of a statute of frauds. So promissory estoppel, detrimental reliance by one of the parties will take the contract out of the statute of frauds. Remember, promissory estoppel, our elements, so we have a promise. The promisor should reasonably foresee that the promisee would rely. The promisee did rely, and in this case we have part performance on the part of the promisee, and we can only avoid injustice by enforcing the promise. Well, in our case, we have a contract between the parties. We have an oral contract. We have assent. We have reasonably certain material terms, and we have consideration. The only thing we don't have is a writing, and we said at the outset that imagine that this is one of those contracts that is within the statute of frauds. So we have a contract, so clearly we have a promise. We have a promise that the promisor should foresee that the other party would rely on it, right? Because we do have a contract. The promisee does rely on it. Well, in our fact pattern, we're saying that we have part performance on the part of the promisee. So it seems like we have many elements that will satisfy promissory estoppel. And once again, there is a specific provision in the restatement of contracts that is promissory estoppel for the statute of frauds. In other words, promissory estoppel will either take the contract out of the statute of frauds, or it will act as a substitute for a writing. Another secondary argument you might have in a statute of fraud case is quasi-contract. So we have full or part performance on the part of the promisee, And now the promisor says the contract is unenforceable because there is no writing. So we could argue promissory estoppel, as we just talked about, or we might argue quasi-contract on behalf of the promisee, right? We'll say the promisee, by performing, conferred some benefit on the part of, conferred some benefit on the promisor, and it wasn't officious because it was under an oral contract, and it wasn't gratuitous because it was under an oral contract where the promisee expected something in return. So if you have a contract that is unenforceable under the statute of frauds, but the promisee, the person trying to enforce the contract, has engaged in some sort of performance, some sort of part performance, consider arguing promissory estoppel or quasi-contract. Or in a more objective manner, consider analyzing, consider doing an investigation of whether this party could recover because of promissory estoppel or because of quasi-contract.